We're live.
All right, we are back in Senate Judiciary, still on S-45. Just a few-minute break, but we have Steve Collier from the Agency of Agriculture. We are, well, in my opinion, I'd like to do some level setting, just regarding required agricultural practices, wastewater laws, and to get you also just to hear a response from you based on everything we just heard. And, I know that as the Judiciary Committee, we don't stray too far into wastewater laws. Ideally, we don't stray into that at all. But yeah, it would just be great to get your perspective for a little bit on what we just heard.
Well, I really appreciate that. Thank you, Mr. Chair. Steve Collier from the Agency of Agriculture. So there's several points that I would make if I can, and I'm happy to answer any questions. One is the issue about the EPA that Mr. Krogman raised is completely irrelevant to this. The EPA issue is simply about which law applies to a farm, federal or state law. He raised an issue about the alleged disagreement between the Agency of Agriculture and ANR. It has no bearing on this case whatsoever. It's about private nuisance law. And a related point, though, and I've heard this before, is that the standard that we're proposing that you create would somehow make neighbors reliant on the Agency of Agriculture or the Agency of ANR to enforce the provisions. That's completely untrue. There is no, all that we asked to do is to make the law clear and for the plaintiff to have to prove a violation. Regardless of whether the Agency of Agriculture or ANR enforces, a plaintiff can still enforce the law. Judge Teachout, in her decision, made that very clear, as you just heard from Claudia Safar, and we agree. It doesn't matter whether we bring an enforcement action or not, if you adopt the language that's proposed, and if a neighbor can prove that a farmer is violating the water quality regulations or the pesticide regulations, or is not practicing in accordance with standard practices, they have a claim. But right now, they don't have to prove any of that. All they have to prove right now is that they allege that there's a nuisance or a trespass on their property, and the farmer has to go through a litany of really unprovable quotients in order to try to gain protection from the defense. If the right to farm law is set up to protect farmers, it doesn't do it. And that is true irrespective of this case. The other thing I've heard for years now is that there's no problem solved because there aren't any suits. That is not true. If the law is bad, the law is bad. The law should tell all parties what's required. When you read a law and you don't know what it means or how it's applied, that's a bad law. I've been in this job now for about 5 years. This law I read pretty early on before the suit came up. And at first I'm like, oh, right to farm protection. That sounds important. And then I read the law and my literal reaction was, you can drive a truck through every single one of these holes that this law creates. So if you're drafting a law that's supposed to tell people what they have to do and what they can't do, the idea should be to tell them specifically so they can actually interpret it. I've been a litigator most of my career, so I know what needs to be done in court, what has to be proven or not proven. This law just creates questions. It doesn't provide answers. That's not fair to anyone. If I'm a neighbor and I don't like what my farm is doing, I should know what I have to do to prove a claim. Hopefully I talk to the farm and resolve it amicably. But even if that doesn't work and I want to prove a violation, I should know what's required. This law doesn't tell you that. It certainly doesn't provide protection for farmers. All it does is say if a farm can prove a whole lot of undefined factors, it has a rebuttable presumption that the plaintiff can still overcome. It's just a bad law. I mean, you can't read this law objectively and say that it's clear. So its application is going to be problematic and inconsistent. I mean, when you have vague parameters and you leave those up to courts, which include judges or juries, it's not fair to ask them to interpret it. What does it mean that you were there first, prior to surrounding non-agricultural activities? Really? How many years are we going back? Are we going back 20, 80, 10, 5? There's no explanation for that. So what that does, it creates uncertainty, and litigation is bred for uncertainty. The only people that benefit from uncertainty in the case are lawyers, because lawyers get to bill for their time. So if there's uncertainty, there's a lot of things to argue about. That's not good for the parties either. It's okay for a party that has a lot of resources, and it doesn't matter if the party loses those resources. But for any party that could not have unlimited funding, uncertainty in the law is costly. And that's one of our biggest concerns about this law is even if the farmer wins, it loses by having to spend money on litigation. And the costs of litigation are exploited by this law because it is so vague and ambiguous. And it puts the burden on the person who's supposed to enjoy the benefit. The farmer is supposed to be protected, but they have the burden of proving they're doing everything right. And that's really not protection. That's a burden that they have to meet. And it's so vague and ambiguous that they really predicting whether or not they can win at the beginning is almost impossible. And that's huge. When you have when you're in litigation, you want to know your risk so you can calculate, maybe I should stop doing this. Maybe I should pay up. Maybe I'm doing everything right. When you look at this law, you can't even evaluate whether or not what your risk is. And if you can't evaluate risk, you're just throwing money away on litigation. It's not good for anything. It's good for a well-heeled claimant. It's not good for anyone else. And right, the way that the law is proposed, there's still plenty of room for nuisance and trespass actions. All a plaintiff has to do is prove that their use or enjoyment of their property is impacted, or there's a trespass and the farmer is violating a related law or is not following good customs and practices. That's not that hard, but the key change is it's now on the plaintiff to prove that. And it should be. If you want to prevail in court and you want to get damages or stop someone else from doing something, it makes sense that the plaintiff has the burden of proving what someone else is doing wrong. And it's not that hard to do that. I mean, first of all, you file a claim. If you're a neighbor who's being impacted, you obviously you have some sense of what's happening on the farm. And there's no litigation. But discovery would be, the plaintiff would be the one that's to dig in, figure out what's going on, and they can't put all of that burden on the farmer. You could design an affirmative defense that made some sense potentially. I don't think that's the way to go. I think the burden should be on the plaintiff. But this affirmative defense is terribly drafted, and it was in response to Iowa Supreme Court decision. So I understand why it's poorly drafted, but it's just not a standard that you can apply. So I mean, that's the key is we all know neighbors need to be protected and farmers need to be protected. But this whole idea of coming to the nuisance worked a lot better when Vermont was 80% farmland and we were, farms were everywhere.
What was that Iowa decision?
So Mr. O'Grady talked about this when he was explaining the genesis of the current language in the bill. But back, I think it was in 1998, but I may be wrong. There was an Iowa Supreme Court decision that talked about it, and Scott Sanderson just referenced this to a potential taking. But then my memory is, and I haven't read that decision in 2 or 3 years, the Supreme Court of Iowa later changed course and decided that it was wrong the first time. I think that's how it went. But this statute was designed in part in concern of what the Iowa Supreme Court had done because its statute was similar. That concern no longer exists. So the reason the statute was drafted the way it is, which is, as many people have discussed, which is poorly drafted because it's so unclear what you have to do, is because of that concern in Iowa from 20 plus years ago.
Do you happen to remember the name of the case?
I don't. I could find it and send it to you.
Not urgent. I was just wondering.
I have read it, but it's been years. So those, I think those are kind of the big issues. But another thing that I don't think has gotten enough attention is, and I don't want to talk specifically about that case that parties have talked about because that case is not why the Agency of Agriculture is here. That case is an example of what can go awry, potentially, but it's not why we're here. But I think we can't overstate the fact that the judge in that case enjoined the smell of manure. The judge in that case said, this farm's manure stinks and they have to stop that. That is a completely untenable standard. And Mr. Borstadog, when he testified, said that he built manure pits when he bought that property. And I think his attorney explained that the judge said that he wasn't entitled to the rebuttable presumption because he had a significant change by building a manure pit. Well, that highlights the crux of the problem that we're in. The state of Vermont requires them to build, Mr. Borstadog, to build manure pits so that they can store their manure so that they can only spread it when it's least likely to run off. So to require him to build manure pits and then to say that that has stored manure can't smell is dangerous. I mean, we only have 441 cow dairies left in the state. You drive out one at a time by a neighbor who comes here for the summer to enjoy our beautiful weather, and you make them responsible for the smell of manure when they're doing things correctly. If it's possible, you could mismanage manure, and you could have. There's all kinds of things you have to do with your manure to store it and apply it correctly under the law. But if you're doing those things and the manure stinks when you're spreading it or when you're agitating in the pit, and to have a neighbor be able to say that's untenable and you have to stop that, there's no way to stop that. So there's no cost-effective way to stop that. And even if you do something like capping your manure pit, then you might be creating a real risk because there's no way for the gases to escape. So like that's a huge issue. I mean, for a judge in Vermont to say cow manure can't stink. I mean so that's part of the reason why we believe this law needs standards. So if you're going to require farms to follow all of these laws, which we agree they should. I mean, these are important water quality laws, important pesticide laws. We all share the same state. Even though farmers are growing our food and they're critically important to the state of Vermont, we still need them to respect their neighbors' rights. But when we set up this whole rubric of things they have to do, and then we allow neighbors to bring claims actually based on what they're requiring them to do, that's a flaw. That's a flaw.
Steve, one question for you regarding water quality. I'm seeing the difference between the current law and the proposed law. When we're looking at those 4 prongs to provide that protection to farmers in the current law. And it says it's conducted in conformity with federal, state, and local laws and regulations, but doesn't specify which ones. Whereas in the proposed law, it's saying that generally accepted ag practices means requirements of 6 ESA, chapter 215, including permit requirements and so on. Is wastewater and the rules surrounding wastewater, are those included in those requirements that I just described?
Yeah, they're incredibly comprehensive. I mean, in chapter 215, it's many, many pages long, and it entails all the things that farms have to do in order to control their farm operations. And they're all based on water quality protections. So, and that includes the required agricultural practices, which are the agency's rules. So as an example, farms aren't allowed to have waste discharged to their neighbor's property. So that's a requirement under the required agricultural practices. So if farms discharge waste to their neighbor's property, that's a violation of the RAPs, and a neighbor could use that to prove its nuisance claim.
So if a plaintiff who if this were to pass, if a plaintiff who has that burden of proving their case, which I think makes sense, if they show that there's wastewater coming onto their property and that it's a violation of whichever specific statute exists for the wastewater requirements, then would that farmer not fall in the generally accepted agricultural practices?
So an important distinction there's waste and then there's water. And so nobody can stop water from going down. Right. So wherever you are upstream in Vermont, if you own property, the water from your land is going on to your lower neighbor. That's just fact. So farms are not required to stop water from coming off their land, but they are required to, when they spread nutrients, to do so. There's many requirements that apply to how they're required to do that. The nutrient management plan, which is something that's adopted, it's a federal standard that we adopt under state law. And that's why they can't, they have to spread so that they don't oversaturate the soil. So nutrients won't be coming off the surface. They can only spread during certain times of the year. They have to have setback and vegetative buffers. There's a whole litany of standards that apply. And the whole goal of that is to ensure that waste is not going to water. So water can have waste or may not have waste. If a farm applies nutrients to their land appropriately, that's considered stormwater runoff that is acceptable and it's not considered waste. If they don't apply their manure properly, then it's waste and then it can be actionable. There's another piece of that. That's state law. There's also a federal law under the Clean Water Act, and any citizen can bring a suit under the Clean Water Act, which is federal law, alleging that a farm is violating the Clean Water Act by discharging water. So this That's part of the whole issue is this nuisance is just a nuisance and trespass. It's old common law that existed long before any of these regulations. But there's all of these additional actions now, like the Clean Water Act and like agency enforcement. So the point is not to detract from property law rights. It's to make those property law rights consistent with the additional regulatory rubric that the state of Vermont and the federal government have created. And that's the plea, is if we're going to set standards for farms, the legislature should set those standards, not neighbors and not individual courts. They're still going to have to apply those standards. There's no perfect way to define it, but the Vermont state legislature should be telling, I think, farmers and neighbors, this is the law that applies to you. So understand what it is. Farms, make sure you comply with it. Neighbors, evaluate whether or not farms are complying with it. And if they're not, and if your property is being impacted, you have every right to bring a claim and every right to win. But having a whole separate standard that comes from common law in England and apply it to the current state where we regulate everything, it's cumbersome, it's burdensome, and it's unfair. And it's not clear. If you want to do something different with that law, we'll work with you on how to do it. But to just leave it as it is, I don't know how to apply it. I've been practicing for 30 years. So I don't know how a neighbor or a farmer is supposed to figure it out.
Senator Buckles.
I certainly appreciate clarity. And if the law is unclear, I definitely think we need to make it more clear. I don't know if this is how to do that, but I appreciate that. This is something I argue in this committee all the time. How do we don't really understand it, expect someone who's just walking down the street, not a lawyer, to understand it. So I really appreciate that. One of my concerns, and I've raised it before, is and it is from my community, is I'm wondering if what constitutes a farm may be too low a farm.
Yeah.
And I just wonder if you have any thoughts on that.
I mean, that's a question I've actually thought a lot about. And it's not, to me, the question arises a little bit differently than in this particular context with nuisance, because it's more about municipal zoning. And so because municipalities cannot institute zoning bylaws for farms, I do wonder whether the current standard for a farm is too low. We think about that. On the other hand, we don't want to stop anyone from growing their own food.
Of course not.
And so what I wonder is, I mean, the basic easy line is everybody ought to be able to grow their own food. Obviously, there's a little bit of difference between having a garden and having livestock. And so I think there could be some room for better addressing livestock in the middle of downtowns, potentially. On the other hand, under the current framework, you really can't comply with the requirements and have livestock downtown. You might be able to have some chickens. You might be able to have a few goats. Those issues are tricky and they're a little outside of this, but the reality is, under the law that's proposed, any neighbor can still bring a nuisance or trespass claim if their neighbor is not containing their agricultural activities. So as an example, you can't have waste. You need to have setbacks for farm buildings. You can't have waste going across property lines. So there are existing protections. I think a quarter-acre lot or a tenth of an acre lot or a half-acre lot probably warrant different evaluations than a 300-acre farm. And I think we've done okay with that. I think we could do better. And I don't think this is the bill for it so much. I think that's probably more of a zoning versus Act 250 versus Agency of Agriculture regulatory question probably than this. But I didn't, and I sent you that. You sort of asked a similar question last time in that email. I do think that farms, under the language as proposed, I do think a court would have the ability to evaluate farming activities on a quarter-acre lot differently than a 300-acre farm. And that just makes sense.
Yeah. Well, and so my concern is if we don't address that, maybe those bars are too low and make it harder for the neighbors to have any recourse. We are caught in the middle. Like, that gives me pause.
Mm-hmm.
I think sometimes we often do one part without the other part and it creates chaos. And so I'm not in any way suggesting that we don't want to protect our farmers. And if the bar, do you see kind of what I'm saying there is I actually think maybe we do need to do both.
the margins are tricky, you know, and part of the reason it's hard to get to clear laws is because we're always trying to tackle margins, understandably, but the more you tackle them, sometimes the more challenging it gets. And I use an example in this particular, in S45, there's this language that Scott Sanderson talked about negligence. I don't think that belongs in there. That was really in it, but it doesn't create, I don't think it creates a negligence standard. I don't think negligence is an entirely different suit where you have to prove a negligence claim, you've got to prove that someone has a duty to you, you breached that duty, and you did something that caused harm to them, that caused damages. This doesn't incorporate negligence into this, but it was really, I think, designed to give a little more protection to neighbors. Because what this says in this proposal is that even if a farmer's doing, you know, everything according to current law and current practices, if they do so negligently, then they wouldn't be covered with protection. I think that's meant to apply to something like, you know, if you're driving if you're spreading manure on a steep bank and it tips over, it all spills onto the neighbor's land, then, you know, maybe you were doing everything right because you can be in the field spreading manure, but maybe you shouldn't have taken the angle you did on the hill. And so you spilled your truck over and spread manure everywhere. That's the situation that I think it's probably meaning to address. But to me, it creates unnecessary questions and more questions and just creates potential ambiguity. So I personally don't think it's value added, but it is additional protection. So, you know, and I think that's in there so that a neighbor with a unique circumstance would still have ability to say, yeah, okay, the farmer maybe didn't violate a law, but look how it did this. It never fixed it. As an example, it didn't fix its fence. So, you know, the bull kept getting out. And I think that's already covered because I think good fencing is incorporated into reasonable practices. So, you know, to me, if a cow gets out because somebody's driving down the road and plows into the fence, so the fence goes down, cows get out, that probably shouldn't be attributed to the farmer. But if a farmer never fixes its fences and those animals are causing harm on a neighbor's property, then yeah, the farmer ought to be responsible for that. And there's just actually separate laws that deal with that too, to animals, in the state and the municipalities have police power to control animals. But that also raises the other question. The other thing we hear about this, there's no problem to solve. That's not true. We get complaints. We hear about complaints all the time. That does not mean they always lead to litigation, but there are always people. Neighbors like to regulate each other. Neighbors like to disagree. We get complaints all the time. And so whether those rise to litigation or not is just one facet. But if parties don't know their rights, and I don't, as a lawyer, I don't like that. I mean, I'm not in a position right now of giving advice to anybody except the state of Vermont. But if I have someone come to me and they want to know what to do about it, and I can't tell them what their chances are, I'm ineffective. And that's the only thing I can say right now is who knows? And that's, you know, you've got arguments, and here's what they are. And that's not a good place to be when you want to know how to implement the law.
Understandable, and there's always some level of uncertainty.
Of course,
Certainly.
of course. And the facts matter. The facts always matter.
You don't know the outcome until the judges rule, right? But I do think if there's a lack of clarity, it makes perfect sense to be more clear.
I think also, to your point, I think, you know, if this were to pass and, you know, it would go to the Committee on Agriculture, and I think that, you know, they could be given the task or the request that they also look into those questions that you just raised about, you know, what's the threshold for somebody who's growing their own food at home for their family versus actually being a farm. So you could have them look more into that. And what I was thinking in my head was having them just also review some of the rules surrounding wastewater, just because in my mind, at least, I just want to make sure that we're not inadvertently opening up the floodgates, no pun intended, but floodgates for pollution and just wastewater going all over the place. I don't see that as a potential issue, but you know, I don't know everything. So
Yeah, no, and on that point, I would say that farms are heavily regulated right now under both state law and federal law. You could always argue that the restrictions should be tighter, but I don't hear that argument. I hear that the enforcement should be stronger. I've heard that. I've heard the penalties should be bigger on farms. I've heard that. But I've not recently heard that the water quality laws that are in place are inadequate. I'm sure that there's some people who believe that, but they're very comprehensive and they do apply under both federal law and state law. There's an entire framework of what farms have to do, and they're new. These are huge costs to farm that threaten their viability for good reason. There's a public benefit to protecting water quality. We need to do that, but it's that balance that we think is also really important in the nuisance trespass threshold from centuries ago doesn't really meet the current framework where farms are being told exactly what they can do and can't do.
Committee, any further questions or comments?
Tricky because it's weighing into an area I have so little knowledge about. Like the underlying legal words I understand from sitting on this committee, but the practice and I spent a bunch of time in the break Googling and learning about tile drainage because I didn't even know what that was. So it makes it really difficult for me to sort of navigate. And so
And to your question about the small town, so the way that farms are determined is under the required agricultural practices. And the sort of default position is that you need to be on 4 acres of land farming. And that's a significant chunk of land. And there's probably room to do a lot of things on 4 acres. But there is one provision where if you have $2,000 in sales of agricultural products, you're also a farm. And that's the most permissive one. And that's where you can really get into the micro kind of farming, which again, we want to protect. It's not growing food for your own family though. That is, you still have to be commercial. You still have to be a farm, quote unquote, a farm. You need to be doing so in a commercial way. So you need to be selling products or have enough animals to be on that 4 acre lot. So we've talked about raising that $2,000 threshold. We're reluctant to do it because farms are already so vulnerable and they're already getting driven out that we don't want to stop people from being able to, and a lot of people don't have money for land. So if you only have money for half an acre of land, but you still are you really want to be responsible for your own food and also selling to your neighbors, we're hesitant about cutting that off. But I do think that there could be protections in the municipal zoning code for small farms that wouldn't necessarily involve the Agency of Agriculture. I think maybe there could be a carve out for towns where if you're under a certain threshold, you have a right to farm there, but maybe certain types of agriculture and not all types of agriculture. But this is not we've talked about this at the agency a lot, but it's not, we haven't formed a definitive position on it yet. We just recognize the vulnerability.
I just feel like with the inflation and the cost, like $2,000 doesn't take much to get to. I mean, eggs are $10 a dozen. Like that doesn't take very long. And so it feels like in 2025, given the state of things, that number's pretty low.
It is. I don't disagree. I don't know exactly what to do about it, but I don't disagree.
I think you have to look at the possibility of not letting someone say in Sheldon where I live to have 2 goats, 100 ducks, meet the $2,000 threshold and affect farming as a whole. The state of Vermont, which obviously relies upon more than $2,000.
Correct. Well, that's a great point. And that's one of the things that, there are certain groups that are very much focused on the small farm and their independence and being able to grow your own food. And there are other people who are focused more on the big farms. Add to the state of Vermont and its economy, obviously the bigger farms are much more significant. And I don't think a 500 cow dairy is easily evaluated against a farmer with a few ducks. They're not doing the same things. They might both deserve protection, but maybe those protections should be very different.
And that's, I think, it's been the tenor of I think our conversation and sort of as I'm looking at this, it's exactly that. What standard and customary for a 500 cow dairy is different than what standard and customary if I have ducks and goats on my quarter acre property with neighbors right next to me.
Yeah.
And I don't want to make it difficult for farmers. And I particularly don't want to make it difficult for small farmers because I think that that's really the most sustainable healthy, like it's one of the beautiful things about Vermont is we don't have giant factory farms. We've got small local farms. And I just think we have to find that balance.
Anything further? Committee? Steve, anything further?
Oh, thank you. So, Ms. Safar has found the Iowa case that we talked about before. If you know what, if you just email that to me, Claudine, I can forward, I can forward it to the committee later. Yeah, thank you.
Mr. Chair, can I just say one thing, just.
I was going to ask,
Yeah.
there was you did raise a point specifically from somebody who was, from John, who had testified earlier regarding the EPA and the fairness. I didn't want to provide a chance to respond to that as well. And I think you also had mentioned something regarding the negligence standard that Mr. Sanderson had highlighted. So I'll give both of you a respond.
I think Steve characterized my script. Yeah, I just like to say two quick things. One is, I think, my point with the EPA petition and the disagreement about whether water quality laws are being applied with shows how complicated it is, that even, it's not even an agreement with the state agencies about what is compliance with water quality laws, and now we're making that the threshold decision for the water quality aspect of the practices to bring one of these suits. And I think that is an issue. I think it shows you, how difficult that is. And traditionally, this has not been about water quality. Bringing trespassing makes it more about water quality, even though I don't know how many water quality nuisances there's been. I don't think there've been very many over the history of this law, but it is a concern that when you put trespassing, you're bringing in this threshold that a plaintiff's going to have to prove something, that there is clear disagreement between the agencies about what constitutes a violation. And we're making it only about state law or federal law violations come into play now. There was a lot of statements about tile drains. My understanding about tile drains is we are not embarking on installing lots of new tile drains. In fact, the debate, to my understanding, has been identifying tile drains that are causing a problem and actually trying to reduce the amount of tile drains. And there's been a debate about that. So I don't agree that we're setting up to focus on lots of problems with tile drains in terms of the nuisance suit, because I think we're grappling with how tile drains are used, how much they should be used, how they should be dealt with, because they cause broader water quality issues. So anyway, I don't want to go tit for tat, but it just shows you how complicated this is. And there's not agreement, not only amongst us, but I think the broader community of people who are talking about farm water pollution and where we're headed and what needs to be done and what these laws require or should require. So I don't want to get into it. Like, this is not the environment committee, but I didn't want the impression to be left that that's agreed upon, because it's not.
Thank you. Senator Hosty.
I appreciate that. In some of my very brief research, I actually also found what you're pointing to, that tile drainage has been used in this area since the 60s, and it appears like we're moving away from it. But again, I'm no expert. But my question actually, and this is just my lack of knowledge in the subject area. Currently, do we rely on state and federal law to trigger these types of claims?
The statute now includes, with the rebuttable presumption, includes state and federal law and local law.
Okay. So I guess my question is if there's any concern that actually we need to be more clear about state law, given the potential for huge rollbacks of federal protection and federal clean water law.
Yes, I think we do.
Okay.
That's a general matter, yes.
Okay, and I'm just wondering how that interplays.
Yeah,
here.
I think that's a bigger issue than this. This is more, I think what Mr. Collier is talking about is how we regulate water pollution on farms and how much we rely on the federal government and the federal laws. The federal laws have not changed and with this administration. Certainly how they're enforced and implemented has changed in some areas already, and we're concerned it could change in this area. But I think, given what's going on with the federal government,
obvious. We just can't rely on them as much, but we are, like the petition that I referenced, you know, the laws on the books. That's the way that the system works, is that EPA has oversight over the states that have delegated these water pollution programs, not just for farms, but for all discharges. And if there are alleged concerns about compliance, then there's a process to get EPA involved. And, you know, we followed that process, and that process still exists. And the people that we work with at EPA are still there as far as we know. Yeah, but
For now.
yeah,
Okay, that's helpful. It occurred to me as that conversation about the interplay between state and federal law was happening, that that's actually an area where, you know, clean water, the EPA as a whole, like that
Yeah.
there's been a lot of,
much bigger concern, but total concern, obviously.
okay. Thank you.
Any further discussion? Been talking about this for almost 2.5 hours now. Okay. So we can conclude this conversation for now. We'll revisit it soon. And just some housekeeping stuff. Tomorrow, we're going to start off very briefly with the vote for S12 and the final walkthrough. And we'll also be getting the miscellaneous judiciary bill and S44, the immigration bill, for the new amendment to it. So that is on the docket for tomorrow. And we can adjourn.